Thank you, everybody, for joining us, and I too want to express my great appreciation that Khaldoun is joining us today. I'm not sure how many of you are familiar with the Walkup firm in San Francisco. It is probably one of the most preeminent plaintiffs' firms in California, and they also handle cases across the nation. And I think Khaldoun brings a perspective to this issue that is very valuable, not only for defense counsel, but for the people who eventually make the decisions on claims. So again, Khaldoun, thank you very much for taking the time out of your busy schedule. He just flew in yesterday, flew in early from Montana to join us here today. So again, I thank you very much. I think this topic, the genesis of this topic, was on one of those moments in which the Walkup firm was perhaps educating me, to put it mildly, on the evaluation and the value of a case. I had perhaps a revelation or an epiphany during that time that perhaps plaintiffs' counsel take into consideration certain factors in evaluating cases that defense counsel and claims adjusters perhaps do not pay sufficient attention to. And it works both ways. I mean, I think there are times that plaintiffs' counsel also put undue emphasis on certain factors. But there are areas that I think we can learn if we want to reach early resolution of claims. I think that's probably the goal for everyone in this room, defense counsel and insurance people, to understand from the plaintiff's perspective what matters, what issues, what topics need to be perhaps better appreciated than they are. So I sat down with Khaldoun and I asked, how do you evaluate a case? What factors do you look at? And interestingly enough, I think we're going to find that for the most part, we do consider and look at the same factors, but there may be certain twists, certain emphasis placed on those factors. And I think you start with a basic concept. Basic concepts with regards to evaluating cases. You then perhaps factor in the impact of certain unique issues, God bless you, and I think you then can arrive at a, if you will, a settlement amount formula, which in your materials you'll see is the last numbered item on our presentation. So we're going to start with, I think, the basic concepts and then factor in the impact of certain unique issues to try to reach that formula. In your material, I just wanted to bring to your attention, there is a checklist for evaluating and reserving personal injury and wrongful death cases. It is not my work product. I would love to give credit to the author, but quite frankly, I forgot who the author was, and I've had that checklist in my desk, and given the topic today, I thought it was abundantly appropriate to include it in our materials. So when we go through the process of evaluating a case, where do we start off? And basically, I think we all agree, we start off with regard to who the potential claimants are in a personal injury case. Obviously, the physically injured party, it can be an adult, it can be a minor. On some occasions, it can be a child who suffered prenatal injuries. We also have a situation where an injury to one person can lead to a compensable loss to somebody else, a spouse, a domestic partner, a close relative, negligent infliction of emotional distress from witnessing an injury, loss of consortium is such a claim. And, Khaldoun, loss of consortium claims are often pled, but I find not taken particularly seriously, often by defense counsel and often by my clients. From your perspective, what is the viability of loss of consortium claims?
Well, first of all, I just want you to know it's not just any defense lawyer that gets me out to Sacramento on a Friday afternoon. My firm has a tremendous amount of respect for Steve and for his office and for the work he does. And we've had some great experiences working cases together very diligently, very effectively, and very aggressively. So loss of consortium claims. Typically speaking, you want to name the spouse on a loss of consortium claim at the outset as a plaintiff's lawyer because you don't want to worry about having to add that claim later, especially if you're close to the verge of the statute. As a general proposition, though, I find that in the evaluation of any case that I have, when an offer is made, I will ask, what about the loss of consortium claim? The adjuster will then say, well, it's a global offer. It's global. But it's his wife. He's really injured. Yeah, it's a global offer. If you have a serious injury, the loss of consortium claim is also serious. And you may not think so. And the defense attorney may not think so. I can assure you that the jury will think so. Because by and large, our jurors are husbands and wives. And so, when I dedicate a substantial portion of my closing to what this means to Mrs. Johnson, who's been there through sickness and in health, and this is not what she signed on for, and as she sat dutifully by him, don't make it easy on me by not offering anything on the loss of consortium claim. It's real. Now, if you got a low-impact rear ender and Mrs. Johnson had to put up with him complaining of back pain, and he had to complain of back pain before anyway, okay, I understand that. And there's one thing I will tell clients when I'm signing them up. If I'm talking to the spouse and say, is he somewhat of a pain now because of this injury? Yes. Was he a pain before this injury? Yes. Well, then we probably don't want a loss of consortium claim here. It's just not going to make sense, right? So if you have a very serious, real injury, severe injury, measurable injury, you're going to have a serious, real, measurable loss of consortium claim. Do not discount those. Juries accept and understand that, and they are looking for ways to compensate those whom they believe have been wronged. And routinely, I think adjusters sort of write it off and just don't include it.
You mentioned to me, I think, when we were talking the other day, about sometimes the inquiries that you get from adjusters, and I might be jumping the gun here, this might be more appropriate for the emotional distress damages and evaluating that, but I think you mentioned something about there are defense attorneys and adjusters who will simply ask you, what are the healthcare expenses?
Yeah.
But there are the other defense attorneys and other adjusters who perhaps ask a different question to give perhaps light to the loss of consortium claim. What is that?
By and large, when I'm dealing with a defense attorney or an adjuster, the most effective ones aren't the ones that say, okay, how long did your client treat? What are the bills? How long after the accident before they sought treatment? And you can hear them doing a checklist in their head. Some of the best defense lawyers I've ever seen and the best adjusters, when I've settled individually with adjusters or in-house, will immediately, first question is, tell me about your client. What's he like? Family? How many kids? Really? Where do they live? Because they're thinking, one, if you file this case, it means you're willing to try it. Two, if you're going to try it, what's a jury going to think of it? Three, how am I going to evaluate what a jury is going to do? And a jury is not going to hear this information presented in the form of, Mr. Johnson, what are your medical bills? How many visits did you have to the doctor? What's my first question? Where do you live? Do you have kids? Do you coach them in Little League? You know, I just gave you 3 questions. You've learned more about Mr. Johnson. Those that take the time to learn the story of who the client is, and it doesn't mean, believe me, it doesn't mean you're soft. It doesn't mean you're rolling over. It means you're doing a very good job of assessing what is this exposure. And if I'm at a loss, if I'm not able to come up with some good answers or some real true answers, then I need to do a better job of learning my case and owning my case. But those tend to be the most effective, that just come right into who is this person we're dealing with? What's a jury going to do with them?
And by the way, I know we try to carve out a little bit of time at the end for questions, but this hopefully is a little bit of a give and take type of presentation. So if anybody has any questions or comments during the course of this presentation, please feel free to raise your hand and ask us questions as we go along. Continuing on with the potential claimants in a wrongful death suit, that can involve a specific class, because a wrongful death case, wrongful death claimants here in California are dictated by statute, and that generally is the parents, the children, their surviving spouse, or their domestic partner. But there are certain twists to the individuals who can be plaintiffs in a wrongful death case, which I think sometimes get overlooked.
Minor plaintiffs who are relying on the decedent for financial support, there's actually, by statute, it sets it up, Code of Civil Procedure 377 et sec, as we lawyers like to say, set forth who can recover on a wrongful death claim. It has come up very rarely for me that a minor child is actually not related to the adult, but if they are relying on them financially, they can make a claim under certain circumstances. Generally speaking, the person who would inherit is the person who can bring a claim as well. That's sort of the easiest the easiest formula, if you will, to apply it. So what you want to look at is if the person is providing economic support to people, those are the evaluating claimants. Another thing you want to make sure is, do you have all the claimants? Is everybody there, right? Good defense lawyers want to know pretty early, who else is out there? Because it's all nice and good if you pay me the policy limit, but then a day before the statute of limitations expires, oh, he had another child who files, that's not a phone call you want to have to make. So generally speaking, you want to make sure you've got all the claimants. He or she who inherits can bring a claim, or if they're supported financially by the decedent, they're going to be able to bring a claim if they're minors.
And the recoverable damages, again, depending upon who we're dealing with, generally financial contribution that the decedent would have made, but for his or her demise, loss of services, advice, training, and then loss of love, companionship, support. What is interesting is there are certain damages that are not recoverable. Punitive damages in a wrongful death case. It's very interesting. Punitive damages in a wrongful death case are not recoverable. And either is grief, sorrow, and mental suffering of the plaintiff for the loss of the decedent. I have found, and maybe you've seen this too, that juries do not truly distinguish between this concept of, well, we can award damages for loss of love, support, companionship, but we cannot award damages for grief and sorrow. Is that something that you have also found?
Yes, and do not waste your time. If you're opposing me in trial, and you get up as the defense lawyer and say, ladies and gentlemen, we're really sorry he's dead, but please don't award any damages for his grief. because you're going to get a lot of people sort of tilting their heads and looking at you. What are you talking about? The jury instruction says you can award damages for the loss of care, comfort, society, solace, and emotional support. But you can't do it for grief. Great. Fine. Do you think I'm going to use any of those words in my closing at all? Am I going to say, ladies and gentlemen, we really want you to award damages for the loss of care, comfort, solace, society, affection, and moral support? That was hard to just say. I'm not going to talk about that. I'm not going to get anywhere near that. So avoid the formulaic effort to say, can you all understand that you're not to give money for grief? Every time you stand in front of a jury, what you're saying is, believe me. Everything you say to a jury is a promise. And that doesn't make sense. I know the law has these structures. We're not going to award for grief. Great. And in a wrongful death case, I've had defense lawyers say, I don't want Mr. Baghdadi arguing that they award damages for grief. Done. Fine. What's next? I'm not going to use that word. I'm not going to speak in the language you ask me to. I'm going to tell stories. I'm going to talk about who the person was. I'm going to talk about who this person is now without them. I'm going to talk about what the family was and what they are now. You're not going to hear the word grief. I don't need to tell you there's grief. I don't need to tell you there's loss of emotional support. You're going to know it when you find that out. So I assure you, if you read in a mediation brief what little Timmy or his sister can no longer do today, don't just say, that's just grief. He's never going to get that recovered. Don't waste your time. That's what comes back to, who is your client? Who is the plaintiff? What is this story? So, and I think, Steve, you agree with me on that.
Yes, I mean, from my experience, it is the plaintiff's attorneys who tell the story, and through the story, develop and establish the nature of the relationship between the plaintiff and the decedent, and through that story, without ever mentioning loss of society, support, companionship, they bring that message home to the jury or to the mediator. And so I don't think it is at all effective to focus in on, well, they're going to be able to recover for this, but they're not going to be able to recover for that. Technically, that is true. But in reality, does it happen? No. There is not the distinguishing between the two that I've been able to find. All right. Again, when we're going through this process of evaluating a case, we need to identify the items of likely compensatory damages. And one of the key aspects of compensatory damages is, of course, the healthcare expenses, both past and future. Past expenses now are subject to the Howell limitation. I'm sure everyone in this room is intimately familiar with the Howell limitation, but essentially past healthcare expenses are limited to the amounts that are actually paid. We don't have any disagreement on that. The defense position is that the full undiscounted amount is irrelevant, inadmissible for any reason. Is that potentially too limited of an approach? How at least is your firm dealing with,
Sure.
with that issue?
Okay, so two things with respect to Hal. First of all, with respect to the past medical expenses, if it is established that that the amount of the paid bills versus the billed bills, which is how I'll refer to them, I'll try to think of it a little more confusingly if possible. But billed bills versus paid bills. Paid bills are lower than billed bills. Why do I want the paid bills in? Because they're larger. Okay, no big secret. Now, the Howell doctrine is that pursuant to a contractual arrangement between the person's carrier and the medical care provider, they have agreed to a discounted amount. By benefit of their Walmart-like purchasing power on the market, they get to pay less. So, there are circumstances where it's not that clear that the amount paid was pursuant to a discounted amount. And I think part of the discovery process is establishing and tying that down. The uncertain issue is, whose burden is that? Do I have to introduce evidence to the judge outside the presence of the jury that this is pursuant to a contract, or as opposed to a gratuitous write-off, as opposed to a billing error? I don't know. But generally speaking, as a practical matter, the plaintiff's attorney and the defense attorney usually should be able to come to some agreement as to what the number is we're dealing with. Why? Because we have other things to be worried about. We've got other things to be worried about. Is the police officer going to show up on the first day? Where's my PowerPoint? I've got so many other things at trial, so the last thing I really need to be worrying about is calling the custodian of records for SF General Hospital to set that out. So that's in terms of the billed versus paid amount. Now, is the larger bill relevant and admissible? Hal explicitly leaves that alone. It says we're making no judgment on that. Can there be circumstances where we, as the plaintiff's bar, can argue it is relevant and it's admissible? Why? It's relevant and admissible for the purposes of non-economic loss. Given the severity of this bill, it's relevant to show what the person went through.
How is the $3 aspirin relevant?
Well, if it's a $3 aspirin, I'm not putting it into evidence. I'll tell you that, right? So, again, the only post-Hal cases I've tried have not involved this issue, and every post-Hal case that I've seen tried involves a stipulation reached by defense counsel and plaintiff's counsel. And the Hal context comes up in the context of private insurers. If you have Medi-Cal, you've got a Nishihama situation, which is different, where it's a post-verdict reduction. So, generally speaking, we're reaching stipulations. Otherwise, if you are seeking to introduce the larger bill, you have to make sure you both understand what the message is going to be to the jury. Because if I get up and say the medical bills were $1,335,000, Mr. Werth gets up and says, yes, the amount paid was $11. What's that thing fluttering about in the room that we're not supposed to discuss? I think I heard someone say it. Insurance. So you may not want that sort of situation, would you? So maybe we should reach a stipulation. I remember I tried a case against State Farm Insurance for insurance agent negligence. The first motion in limine was that we not mention insurance. And the judge said, is this really how you want to get started, counsel? It was very funny because the judge said, everybody knows it's out there. We're just not going to mention it. And you want to be very wary of this minefield. If you can reach a deal, reach it. Okay? If you can reach a deal, reach it. Because some plaintiffs' lawyers may just as well say, yeah, that's the amount billed. It's insurance. There might be other insurance out there, guys. So.
All right, so we can agree that the discounted amount is the appropriate amount for past health care expenses.
The discount is the appropriate recovered amount, yes.
So we turn, though, to the future health care expenses. And in the defense position, we would like to argue, and we have, I think, attempted to argue, that the appropriate evidence is that the future amounts, like the past amounts, will be discounted. However, that has been met with the argument that, well, that calls for a great deal of speculation.
Correct.
Is that the approach that you also take?
Yes.
With regard to that?
Surprise, yes. Yeah, I've not had a judge yet allow someone to testify that these are Mr. Johnston, and by the way, I don't have a case now named Johnson, I just keep using that. This is Mr. Johnson's future medical care. This is the cost of future care. We've got our life care planners and our economists. But we think Mr. Johnson is going to have Blue Shield. And as a result of Blue Shield, this is what the future is going to hold in terms of his co-pays, his deductible. So in fact, really, it's going to be a couple $100 a year, tops, if anything. In fact, we probably did him a favor. You just carry it to a logical conclusion. Every single time we have deposed the expert or experts who say, I can state within a reasonable degree of scientific certainty that there will be a collateral source available in the future. it's a bad deposition for you collectively, defense, because it's speculative, and I've never had a judge allow it. I've just never had a judge allow it, and
Is that another area where it makes sense to try to reach an agreement as much as possible as to the cost of future healthcare expenses?
yes, but it's very rare that it happens. The differences often happen on the economist and the assumptions that are made for present value discounts, for whether you're taking the full household income for the purposes of calculating consumption. There are the economists whom you know that handle it a certain way, and it's usually the battle of the economists. I find it hard sometimes to get a stipulation. If you can get one, great, because it's just one less thing you need to be worrying about. I don't know if I've ever had a stipulated future medical bill amount or a loss of future needs. There are times, I'll tell you, where if I've had a defense medical exam and that doctor is even more liberal in terms of what their prognosis is, I will absolutely adopt that, and I'll have my life care planner make a plan for that one. And I'll put them both in. I've got benchmarks now, right? So.
Question in the corner.
I'm wondering about lien agreements. We get more and more cases where actually the plaintiff's attorney sometimes refer the patients to a medical provider and nothing is actually paid. It's all pursuant to a lien agreement. And I think a lot of them are still fighting that they don't have to produce a lien agreement. But what's been your experience when nothing's actually been paid and it's uncertain how much this medical provider may or may not discount? Have you had to deal with that issue?
Fortunately, no. I have had, the closest thing I can think of is a person who's received medical care, there's a bill outstanding, and there's been no payment for it anyway. They're on the verge of collections. That's a debt. That is owed.
Right.
There's no contractual agreement whereby they've agreed to forestall, reduce, discount, or otherwise receive any consideration that's tied to the outcome of the case. So I've just not encountered that. And I can't speak to the discoverability of it. So I've not had that situation. I've not had, surgical care that was performed pursuant. Yeah, I've just not had that.
Yeah, and I think under those circumstances, I would think that the billed amount is going to be admitted into evidence.
Sure.
And it's going to be the defense's burden to establish that that is not going to be, in fact, the amount that will be charged, that there will be a lesser amount that is paid. So.
And I can tell you, I mean, what are we arguing about here? We're arguing about the reasonable value of the medical services. Right. And can you plausibly and justifiably argue that it was reasonable that this is the bill, that this service costs this much? And so you've had a long history of medical care providers charging a very large amount of money. And the plaintiffs are bearing the brunt of it now with respect to Howell and how it's come down. So, I'm sorry, there was a question in the very back.
Just building on her question, we have seen, and if I'm sorry, we being my company has seen, I don't know that that's, yeah, thank you, is relevant as much as the fact that these lien bills where people then have been treated for some time, they then obtain a counsel, plaintiff's counsel, they go out and they're referred to medical facilities. And the facilities, the doctors, et cetera, treat these people. And then they send a bill that, in the opinion of reasonable minds, would say they're exorbitant. And certainly don't express the realities of what the treatment was, the dollar per value. And as I hear you, you're saying that that isn't really going to be an issue. And I'm wondering, and seeing it, that can be an issue if the defense counsel is able to find a provider or an expert, if you will, who will testify that we're not challenging what treatment was made, but we're challenging that the bills were reasonable, and they have scientific evidence and research to show that the very people who did that charged different prices, and the facilities that they used charged different prices earlier. So we've seen some big advantages in reducing those liens, if you will.
And what I could tell you is be mindful of that thing lurking in the back of the room that you don't want to discuss, because if you come in and say, that's not the reasonable value of the services, what is the reasonable value? The Blue Shield rate. Really? Insurance? So I think what the reasonable value of medical services is subject of expert opinion testimony, period. I certainly could not make a motion saying Mr. Werth should not be allowed to opine on what the reasonable value of the services are. Most of the time, the disparity is just not that large. It really isn't. We're talking about a margin that's just not that substantial. But if I came in and said, yeah, he's got a fractured foot and it's going to be $7 million for that cast.
See, the advantage of working with the Walkup firm is you are dealing with knowledgeable, reasonable attorneys. And you do not want to get into, from the defense perspective, a situation where that becomes now the focus of the case. You have your expert getting on there to talk about the reasonable value of services. You have the plaintiff's doctors talking about, well, this is the reasonable value of the services. And all the while, you have the plaintiff sitting there and the jury getting bored. That is an area where I think is ripe for some type of pretrial resolution settlement agreement between the parties.
If you want to spend a half a day of testimony having me go through each and every piece of medical equipment that Mr. Johnson is going to need, I'm fine with that. So be careful what you ask for. If you really want to get into a battle, that's fine. Let's talk about, the sponge that he needs to use because he can't get out of bed. We can get into that. That's fine. And if that's what we're spending our time talking about, I can be there. Again, the benefit of having a good defense lawyer is just that. Do I really need to be arguing about this? How about we make an agreement and move on and argue about whose fault this is, where I think we've got a lot more to talk about, right? If it's a serious injury, again, these are not areas you want to really choose your battles here. You don't want to be penny wise and pound foolish.
And we do have to move on to the next element of damages, loss of earnings. We're going to, I think, move through this area pretty quickly. Past loss of earnings, it's gross earnings, no deduction for income tax liability. Benefits from collateral sources such as sick pay or disability pay is not credited against past loss of earnings claims. You also have particular issues pertaining to self-employed claimants and unemployed claimants. And I think that these types of claimants, particularly the unemployed claimants, present pretty substantial hurdles for plaintiffs' counsel with regard to establishing with certainty the loss of income claim. From, again, your perspective, do self-employed plaintiffs present a particular challenge?
Yes, if I can't, if I'm sitting with a small business owner, he says, do you have any idea how much money I lost? And I said, no, I don't. Can you prove it to me? Because I've got to prove it to a jury. And by this point in the trial, I'm pretty sure I can't use the old, oh, take my word for it approach. I need paper. I got to put it up. I need spreadsheets. I need P&Ls. I need paper. I don't need an economist to come in and say, Mr. Johnson lost $2 million in fiscal year 2010. How come? Because he told me he did. So self-employed claimants who do a good job of keeping their papers organized, who are squared away, you can do it, and it's very doable because they're usually providing you with the information that you need. People that don't do a good job of keeping their books, it's harder to. Again, if they're disorganized in how they're doing it, it's just hard. And it's our job to try to make it make sense, to be clear, concise, to show a drop-off in income. If there is no drop-off in income, then why are we making the claim? Right? So we too have to be careful what we ask for. If you earn more the year you got hurt, really? Maybe we shouldn't be submitting that. Maybe we should just not even claim it in discovery. Maybe we should spare ourselves an hour of deposition time listening to this stuff, right? So, yeah, if it's organized, if it's there, and if I can line it up, absolutely, we claim it. But there's always a challenge. It's not like a W-2 employee where you can just see a very clear mark.
We've talked about those areas that potentially are ripe for an agreement. One area that I've never seen, actually, plaintiffs and defense agree upon is the future loss of income claim. There's two critical factors in establishing future loss of income. The certainty of the work lost time, the certainty of the future earnings, and there's a lot of assumptions that go in to that type of analysis. The assumptions pertaining to promotions, the assumptions pertaining to salary increases, assumptions pertaining to economic trends. Yeah. Is that an area that we will ever be able to agree upon?
The moment I say there is no claim, I'm pretty sure we'll get a stipulation. Once I waive it, I bet we'll be able to get a stipulation. That's just my suspicion. But generally speaking, I don't see, you're providing too much countenance, if you will, to my claim if we just agree that this is what a future loss of income is. I think it's just too hard to do.
A little brief aside, occasionally you may confront a situation where the plaintiff is an undocumented alien. The plaintiff's status in this country has to be determined by the court outside the presence of the jury. If the determination is in favor of the defense, then the future loss of income claim is limited to the country of that individual's citizenship. So that's a little twist that we see on occasion. Loss of income amounts have to be discounted to present value. That requires the ascertaining of an appropriate discount rate. I do not see that much of a difference between our economists and your economists with regard to the discount.
No.
I don't think present value is really an issue, at least at this time.
Thanks to current interest rates, no. No, there's just not much of a disparity there. It's more what you think the person's going to need in the future in terms of the life care plan, but in terms of what's getting plugged in, nowadays the economists tend to be pretty similar.
Another concept of loss of income is the concept of impaired earning capacity, a little bit different than past loss of income. It refers to the extent that the injury interferes with the ability to obtain a better paying position or a promotion. Again, from my experience, that truly requires a great deal of compelling evidence, compelling proof.
Correct.
So,
and there was an example that you and I had. I had a case where a young woman who was no longer able to do the job that she had once did, the deposition of the supervisor, and the supervisor said she was exceptional, and, just exceptional, and I know, it's hard for me to say, but someday she'd have had my job. And as we're walking out, the defense lawyer says, see, that's not, you're not going to fly on that failure to advance claim, because she said, I wasn't sure. I said, that's fine, but I bet you the jury's going to figure some way out to make it up to her. And your jury will find a way. Don't get caught up in the mechanics, like I said. If the jury likes this person, I'm already thinking about how it can help me on my non-economic loss case about how special this young lady was, not did I fail to make my bones on the failure to advance claim. So remember, back up here. Who's evaluating this? It's not you. You're not on my jury. None of you are on my jury that I can help it. So you want to think about who's evaluating this. So just because I can't get there doesn't mean we can't find a way for the jury to do something about this.
Which probably is a good segue into the catch-all non-economic damages, pain, and suffering. And we touched upon it earlier, perhaps, the appropriate way to evaluate such a claim, because unfortunately there is still the concept of, well, it's this type of injury, therefore this has to be the amount of the non-economic damages, or this is the amount of the healthcare expenses, we're not giving any more than twice that in non-economic damages. And that type of approach, that multiplier approach, if you will, is something that is just simply not tenable. And it really does depend in evaluating the non-economic damages component to get that entire story, if you will, which you
Yes.
touched upon.
Yes.
Just briefly, I wanted to bring your attention to Proposition 213, just to remind you that that precludes non-economic damages for convicted drunk drivers and for uninsured motorists. I wanted to touch a little bit upon the prospect, the potential of punitive damages and the impact that that has on evaluating cases. You know, candidly, I have seen punitive damages pled in a number of cases. I do now a significant number of employment cases, and that's typically thrown in there. But also, candidly, I do not find that the addition of a punitive damages claim does much to push the evaluation of the claim or the case northward, unless, of course, you are dealing with a really, really bad situation. From your perspective, do punitive damage claims push that value northward?
Generally speaking, I don't plead punitive damages without consulting with one of my partners, because we take it seriously. We don't, he tripped and fell, so I'm going to make a punitive damage claim. Really? But if I have someone who's a drunk driver and they strike my client and they seriously injure him, I'm absolutely going to plead punitive damages. That's reckless conduct. But the punitive damage component allegation there is, generally speaking, in most of the cases that I've seen, someone's operating a vehicle under the influence. At that point, eventually, I know the policy is going to be in play, so to speak. The policy is going to be an issue there. Did the punitives really take me up and over the edge? I don't know. I mean, I've not seen that be an issue. There are some times when you might want to run the risk of, I've pled punitive damages, do you want to come in and admit liability now? How can you do that if there's a punitive damage allegation? You can say he was really negligent. Yeah, we admit he was negligent. He wasn't reckless. That's a very hard line to draw. So often we'll make that claim because we know it puts the defendant in a tough spot. Generally speaking, though, the severity of the injury and the severity of the conduct are what's there. It hasn't been, in my experience, one. We have it in medical device cases where we've pled it, where we feel there's been a real pattern of misconduct here. But in your, what we often call garden variety personal injury claims, it doesn't come up that often. And when it does, the conduct is sufficiently egregious that the policy is going to get paid eventually at some point.
And punitive damages claims are, besides being difficult to prove, they have to bear a reasonable relationship to the compensatory damages, and that's usually a single-digit ratio. Otherwise, it's going to be subject to an appeal. If you are seeking punitive damages against the employer, respondeat superior, that notion that the employer is responsible for the actions of an employee are not sufficient. You still have to establish advanced knowledge of that employee's unfitness, or that the employer authorized or ratified the employee's really bad conduct. And generally speaking, the amount of punitive damages will not be allowed to exceed 10% or so of the defendant's net worth. So, in my view, punitive damage claims simply do not have a lot of traction.
Okay. I will disagree in one respect. One, if it's out there and if you're looking at the conduct and if it sort of makes you shake your head and sort of inhale when you read what happened, what that punitive damage claim will allow, if it passes muster, you're going to bifurcate your trial, is evidence of the financial condition of the defendant. And that can hurt. So I think you just want to be cognizant of what it enables the other side to do if they pass the hurdle. Now, to prove punitive damages, I have to show malice, recklessness, despicable conduct by clear and convincing evidence, which is higher standard than simply more likely than not. The last case I tried, I was able to recover punitive damages. I had a drunk driver, though. you know what? I didn't need to show clear and convincing evidence. I don't think the jury cared what clear and convincing evidence was. I'm sure they did care what it was, but when you have the type of conduct that is rising to that level, I'm not sure there's much of a distinction. But again, most of this comes up in the context of intoxicated drivers in my practice. I don't do employment work, so I've not had that much exposure to it, so.
Prejudgment interest, I don't think should be overlooked in evaluating a case. A 998 offer is rejected, and you beat that at trial. I think you're entitled to 10% interest from the time the offer is made through the judgment, correct?
Correct.
So let's talk about some other factors affecting the settlement value. We're all familiar with Proposition 51, that non-economic damages, emotional distress damages are severable, not joint and severable like economic damages. But sometimes I wonder if that is overemphasized, particularly with regard to the empty chair tortfeasor. And by the empty chair tortfeasor, I mean the judgment-proof, really bad person who's just not there in front of the jury, was never named as a defendant because perhaps the defendant is sitting in Vacaville or Soledad somewhere. It's just not worth it. And just not in the case. Empty chair. And the question is, how much will the jury apportion to that really bad defendant who's not here? All that we see is the empty chair. Candidly, in my experience, I'm surprised at how small of an amount a jury will apportion to that empty chair.
Yes.
Has that been your experience?
Yes. The empty chair can't defend itself, but the empty chair gets old. It becomes desensitized very quickly, and the jury's going to start recognizing this as this sort of go-to mantra. What about the criminal defendant? What about, well, you're here, Mr. Defendant, and if the jury likes your plaintiff, they're gonna do right by that plaintiff, I think. So I think there's often a lot of overemphasis on what a jury is going to apportion to that empty chair, and the way that Prop 51 works, 1% finding of liability on your client, if there's substantial economic damages, that's going to hit, so.
And I found it's very difficult to explain to clients, look, I know we were perhaps negligent, and this person over here was really, really negligent or criminally negligent, but a jury is not going to apportion 70, 80, 90% to that party. I mean, does it happen at times? Yes. But generally speaking, the party that is in front of the jury is the party that's going to get hit with the lion's share of responsibility.
And what I often tell
So
defendants.
is that 2 minutes or piece?
Right on.
Okay, all right.
And just one thing I tell defendants, the chair is empty, but it's not on my side of the courtroom. All right?
All right, let's turn to, again, just some other relevant factors affecting settlement value. Venue, where the case will be tried.
Can I just say I appreciate you putting sympathetic in quotes? Let's not make a mistake where I am. You and your sympathetic plaintiffs.
Well, you'll also notice that
Got
I
a
put,
wrongful death case.
fair enough, but I did put target in.
You
in
did,
quotes
you
too,
did put
all
target,
right?
okay,
So I'm
yeah.
trying to kind of balance it out there. All right, so venue, where a case will be tried,
Very important.
very important. Because San Rafael is different than Hanford as far as
Yes.
what juries will award.
Yes, it is.
And that needs to be taken into consideration.
Yes, it is.
What I meant by the target defendants and the sympathetic plaintiffs is it's an area that I think is underappreciated both by sometimes the plaintiffs and by the defense in evaluating how that individual will come across in front of a jury. You can have a wonderful case, but if your client is miserable, that's going to affect the value of the case.
Of course.
On the other hand, if I have a good defense case, but I don't have the actors and actresses who will put on that case, who will tell that story, I'm not going to do very well at trial. So I think that's an area that is often not appreciated enough in evaluating the case. Do we have a quote-unquote sympathetic plaintiff who, and I can tell you, this is scar tissue talking, because I took it from this firm when I was dealing with essentially a Mother Teresa type of plaintiff, and I didn't truly appreciate it. And it was a bulletproof plaintiff. And it had a huge impact on a jury. Took what might be one value for a different type of plaintiff, and it just expanded it because this is the person that you're dealing with.
And in those cases, too, we also see on the defense side who's testifying for this defendant corporation. Who's the face of the company? And a lot of times when the corporate witness gets put up for deposition and I'm videotaping it for a reason.
Reputation of attorneys, I think, present company excluded, it does in fact impact the value of the case.
It impacts our evaluation, too.
The impact of lien claimants on settlement value, we don't have enough time to talk about Medicare liens. I wanted to raise the point of workers' compensation liens and the effect of employers' negligence on the workers' compensation lien. This is one of those areas where Khaldoun and I can work together for a mutual interest. This is a situation where you have a workers' compensation lien that's being asserted, and you have a situation where there is employer negligence. And employer negligence will reduce the amount of the recoverable workers' compensation lien, and that can have a huge impact on the evaluation of the case. Correct?
Yes.
All right. So we are being given the thumbs up here. I wanted to end it on this note. This is my formula. It is perhaps now been compared with Einstein's theory of relativity. And that is a reasonable, a settlement amount formula, first determining a reasonable jury verdict, less the percentage share of the plaintiff's negligence or potentially the third-party negligence, less the percentage chance of obtaining a defense verdict. I know you have at the flip side the percentage chance of obtaining the plaintiff's verdict. That should get us into the ballpark if we can agree on a lot of these other numbers,
Yeah,
correct?
the biggest dispute is going to be the inputs.
So,
What's a reasonable jury verdict for me? What does reasonable mean to me? Reasonable is different for me in the context of comparative fault than it is in a jury verdict, right? So, yes, but that's a really good framework, and that's what a lot of mediators end up doing. And then where we disagree is what do I think a jury's going to do with it, so.
with that, we are being given the end it all
High
sign.
sign.
So thank you very much. Thank you.